Hi, this is Mike Maslanka. I wish I had $100 for every time a company manager told me that, by God, Texas is a right-to-work state, and I will fire anyone I want to, anytime I want to. Well, not quite. There's a difference between right-to-work and at-will employment. Let's talk a minute about the difference. Right-to-work only applies if an employee's job terms are governed by a union contract or federal law. The contract is not allowed to require an employee to join the union to keep her job. At will is different. It means that you can leave the job anytime you want, and the company can toss you anytime it wants. But, and like many things in the law, it's a big but, there are loopholes. Here's one from a case in Texas. A safety director at a bus company complains to management that the drivers are not following safety rules, and he worries he will be fired if he presses the issue. An exec at the company tells him, "Don't worry, we won't fire you as long as you keep us in compliance." Sounds like a promise, doesn't it? Well, he gets fired, says the company broke its promise, and a jury gives him $163,000. The appeals court tells him he can keep it. Or a woman works for a company for 17 years. The company has an anti-nepotism policy, but does not enforce it as to her. Turns out she and her brother worked at the same location. The Texas Supreme Court in her case says this: the company nuked the at-will shield by not enforcing its policy, created an implicit contract with her, and breached it by firing her. That's employment law for you. You think it means one thing, and it turns out to mean another. This is Mike Maslanka at your desk.